Welcome back. I'm Rebecca Berger. This is Justice for All, and we're talking to Dave Stern, and we're talking about workers' compensation. So, Dave, before we went to commercial break, I was telling you I kind of want to get into this whole issue of personal injury. So you could have a workers' compensation claim, but you may also have a personal injury claim as well, correct?
Right. So that's commonly referred to as a third-party claim. There's a third party at fault for the injury. So if you're injured at work, and employer's at fault, or you're at fault, or nobody's at fault, then your claim is limited to your workers' comp claim. Those are all the benefits that you can pursue. However, if your injury is at the fault of a third party, someone beside yourself and the employer, then you may have a separate claim against that third party. The most common scenario is a motor vehicle accident. So you drive, part of your job involves driving, and you get rear-ended at a stoplight while you're working in that vehicle. Sure, you've got your workers' compensation claim with whoever your employer is, but then you have a third party action against the driver that struck you from behind.
So usually in personal injury actions, there's multiple pieces of that claim. So there could be damages, there could be lost wages, pain and suffering. What happens with the workers' compensation piece? I mean, obviously, there's no way you can double collect. So what happens in that scenario?
Right. So there's something in the law called subrogation. And what that means is, let's just take the example I just used of the motor vehicle accident. So you're receiving workers' compensation benefits from your employer because you're in this accident, and then you make this claim against the driver of the vehicle that struck you. Well, if you make a financial recovery against the driver of the other vehicle, then the workers' compensation carrier can actually come in and get a piece of the money that you recover from the other driver. So that's what's known as subrogation, and I guess kind of works against that double dip that you're making reference to.
But is it limited to the lost wages piece of that recovery?
No, it's the entire amount of the third party award is subject to subrogation, unless there's a consortium piece, meaning let's say the spouse, it's a significant enough event that the spouse actually suffers damages as well and has a separate consortium claim in the motor vehicle case. Well, whatever is awarded to the spouse, that the workers' comp insurance company can't recover from that award because that spouse wasn't the party in the workers' comp case. But no, the pain and suffering portion of the third party settlement is also subject to subrogation.
So is it capped at the amount that they would normally receive in the workers' comp realm of what they would have received there?
It's like a percentage. There's a formula that's too complicated to even kind of get delved into. But there is a calculation based on how much was paid in the workers' comp case as to how much the workers' comp insurance company can recover from the injured party out of their third party case.
So I can't imagine that these cases don't involve a number of physicians and hospitals for these injuries.
Sure. Yeah. Usually depends on the nature of the injury, of course. The more significant, you're going to have, probably an emergency room visit, a primary care physician or an occupational medicine doctor who kind of is the quarterback of the case, and then maybe a surgeon. Maybe there's a neurologic component to it. So yeah, there can definitely be, a handful of doctors as well. And then it can delve into other things such as, psychological. There could be a psychologist or psychiatrist involved. So yeah, it can kind of run the spectrum of medical disciplines for sure.
So you have the treating physicians, but are you normally required to retain expert testimony as well?
I mean, you can, at least I've always found in the workers' compensation cases that I've handled is the most credible physician is the treating physician, the person that has seen my client a number of times versus, retaining one expert to possibly look at my client once or maybe just review records. That person just hasn't spent the amount of time with my client that the treating physician has. So I usually rely on the treating physician as my expert, and judges tend to, give more credence to a treating physician because of their familiarity from having seen the patient so many times.
So when you're looking at these cases, is there any specific law that's problematic in the workers' compensation realm?
Well, I wouldn't say problematic. I mean, I think there are various nuances that in the law that could use some attention. We talked about cost of living increases. That's something that I think should be addressed. Every year, the workers' comp benefit rate is a percentage of your pay, but there's a cap. So every year there's a maximum amount of workers' compensation benefits. So a higher wage earner, let's say somebody who's used to making $2,000 a week, perhaps a union worker, they might be capped out at like $1,000 or $1,100, somewhere in that neighborhood, and that just simply seems unfair to me. If you're used to kind of making financial decisions for your family based on your $2,000 a week income, and now you're capped at a figure. So there's different kind of parts of the law that I think could use some tweaking for sure. But not one thing that I think is what I always view as being a problem.